Thank you everyone for being here tonight for Don't Lose Your Home, Navigating Foreclosure as a Homeowner. So glad that you could join us. This webinar is brought to you by Brooklyn Legal Services Corporation A and our Consumer and Economic Advocacy Program. My name is Will Greenberg. I'm the Development and Communications Coordinator here at Brooklyn A. And first I want to just tell you a little bit about our organization if you're not familiar with us. We believe that all New Yorkers should have equal access to legal services to seek justice, make their voices heard, and overcome systemic racism and oppression. We were established in 1968 as part of the War on Poverty, and Brooklyn A believes that attorneys have a critical role to play in combating poverty, inequity, and racism. Our civil legal services, our organizing efforts, educational resources, and more assist our clients and their communities in defending and mobilizing against harassment, displacement, and gentrification, and asserting their rights. So tonight's program, as I mentioned, is coming from our Consumer and Economic Advocacy Program, or CEA, where the team works to prevent foreclosures, defend against predatory lending, resolves tax issues with the IRS for low-income taxpayers, and strives to ensure that vulnerable groups have strong safeguards in place to help them build and maintain assets throughout their financial lives. Additionally, this CEA program has a domestic violence unit that offers assistance with orders protection, child custody, and support, and more. I'll go back a slide here to tell you about our other two main programs at Brooklyn A. Our Preserving Affordable Housing Program, or PAH, works on eviction prevention, anti-harassment, fair housing claims, repairs and essential services, as well as tenant organizing. And our Community and Economic Development Program, or CED, houses our Commercial Lease Assistance Program, the CLA program, works on commercial leases for new and existing businesses, offers advice on laws and options for small businesses, negotiates rent and arrears, does commercial tenant harassment work, and also works with nonprofit entities and advocacy organizations on things like incorporation, starting up, and other types of services. So tonight's presenters are from the CEA teams, interns for the summer. We're very happy to have them presenting. We have with us tonight Simon Harris, who comes to us from Fordham University School of Law, and Ruhee Singh, intern from the Brooklyn Law School. And we also have on with us our head of the CEA program, Director Tamara Carmen. So glad that she could join. And we will have questions and answers at the end. So let me just run through the agenda, and the team will all be available to answer your questions. We'll go through mortgage terms, what to do if you're unable to pay your mortgage, go through what foreclosures are and the timeline of a foreclosure, what to do when you miss payments, and define modifications for you, and give you more details about how Brooklyn A can help you. And then we'll get into questions. So please hold on to your questions until the end. We'll run through the whole program, and then we'll take everybody's questions. You can ask via either the chat. You'll see that there's a little Q&A box you'll see on the bottom of your Zoom screen, and that's the best place if you want to type your question. If you want to ask your question verbally, when we get to that stage, you can click the little raise your hand button, and that'll indicate to me that you want to ask something, and I'll be able to unmute you so you can speak directly with the panelists. And with that, I believe we're ready to go. So I'm going to go ahead and mute myself and turn it over to Simon.
Hi, everyone. Good evening. Thank you, Will, for the introduction. And I just wanted to say, yep, I'm Simon. I'm a rising 2L at Fordham University School of Law. And I'm going to let my other co-panelists introduce herself before we get started.
Hi, everyone. My name is Ruhee Singh. I'm also a rising 2L at Brooklyn Law School. I just want to say thank you so much for being here this evening.
Thank you. So we wanted to start off with just some basic terminology before we proceed later into the presentation. So first, you have your mortgage lender, and this is the financial institution that loaned you the money to purchase your property. Then you also have your mortgage servicer. This is the company that collects your monthly mortgage payments and in some instances manages your escrow account, and we'll explain that later. They do not necessarily have to be the same company. Next slide, please, Will. Yeah, so now you have your mortgage terms. Now, a typical mortgage is composed of these three components. You have your principal, which is the sum of money you borrowed from your lender. Then you have your interest rate, which is the rate charged by the lender for that loan. And then you have your escrow payment. Now, your escrow payment is typically composed of your property taxes and your homeowner's insurance. Next slide, please. Now, situations arise that may lead you to be unable to pay your mortgage. The first thing you should do is contact your mortgage servicer. You could be eligible for forbearance. The next thing is to reach out for help. In New York City, there's a bunch of available free legal service providers that are willing and able to help you. We recommend do not making any partial payments on your mortgage. The servicer will not credit your account with the partial payment. It is best to put that money aside and save up your money so you can resolve the mortgage delinquency at a later time. And finally, beware of scams. There are bad third parties out there that could be looking to take your property from you. Next slide, please.
So, thank you, Simon. What exactly is foreclosure? When we talk about foreclosure, what specifically does that mean? So foreclosure is a lawsuit that the mortgage holder files against a homeowner in the Supreme Court where the property is located, and the mortgage holder is usually a financial institution. And foreclosure means or begins when the lawsuit is actually filed. And now this is a common misconception that if you're in foreclosure, you need to vacate the property. A homeowner is allowed to stay and remain the owner of the property until the property is actually auctioned. You are, as a homeowner, are allowed to stay in your home up until the property is fully auctioned. But during foreclosure, you do have the right to stay in your home. Next slide, please. So here's a brief chart about the foreclosure process in the state of New York. It starts with your missed payments, and then you're going to go into a 90-day pre-foreclosure notice. This means that the lender must mail you information on getting help at least 90 days prior to starting a court case. Please do not wait to get help at this point. Time is really of the essence. The next step is the foreclosure case actually being started. You'll be served with a summons and a complaint, either in person or by mail. Once you receive a summons and a complaint, you will have to answer it. And after the answer is due, there starts a series of mandatory settlement conferences. These conferences are very, very important. And there's something that it's very important to attend if you see something that's referring to a mandatory settlement conference. Next slide, please. So just to go over some terminology again, missed payments might be referred to as defaults and arrears. A default occurs when a borrower fails to meet the legal obligations or conditions of a loan. This typically involves not making the required payments on time. And arrears similarly refers to an unpaid or overdue debts or payments that are past their due date. When an account is in arrears, it means that the borrower or debtor has missed one or more of those scheduled payments. Next slide, please. So, what's a loan modification? A loan modification is a change to the terms of an existing loan by the lender. It's usually done to help borrowers who are struggling to make their mortgage payments. And modifications can include changes to the interest rate or the loan term, but the overall goal is to resolve mortgage delinquency. Next slide, please. So here are some examples of how a modification might look. There might be an interest rate adjustment, which reduces the interest rate to lower the monthly payment. You also have loan term extensions, which extends the length of the loan to reduce the monthly payment. You can have a principal forbearance, which defers a portion of the principal amount to be paid back later. You might also have a principal reduction, which reduces the overall principal amount owed. And finally, you might switch loan types, and you could change from an adjustable rate mortgage, an ARM, to a fixed rate mortgage for more stability. The loan modifications are typically used as an alternative for foreclosure for homeowners who are facing financial hardship. Next slide, please. So, what documents might you need? This is not an exhaustive list. Depending on your specific situation, you might need to provide other documents, but some of the things you may be asked to produce are bank statements, recent pay stubs, tax returns, proof of income, the loan modification assistance forms that apply to your situation, and a hardship letter. And a hardship letter is particularly important because it gives you another chance to explain why you may have missed a payment or why you're in need of a loan modification. And it's just another way to kind of state your case. But again, this is not an exhaustive list. These are just some of the examples of what you might need to produce. Next slide, please.
Thank you, Ruhee. So there are a couple of pre-foreclosure notices that a borrower may receive prior to foreclosure action being taken. The first of which is the acceleration letter. Before filing a foreclosure action against a homeowner, a lender typically, does not have to, but typically will send an acceleration letter. The letter tells the borrower that the lender will accelerate the entire amount of the mortgage if the arrears, as Ruhee explained, delinquent balance is not paid by a certain date. And just to further elaborate on default, a borrower is considered in default after one missed monthly mortgage payment. Typically, though, a servicer will not send the acceleration letter after 2 to 3 missed payments. Next slide, please. Now, by law, a servicer has to send a 90-day pre-foreclosure notice. The lender must send the borrower a special notice at least 90 days before initiating foreclosure action. Next slide, please. 1304 is another mandatory notice that a servicer has to, or the financial institution has to send to the borrower when they're undergoing foreclosure action. The notice has to be sent via certified mail and regular mail. And it's very important for you to look out for these notices, because if you do not receive one, it could be grounds to stop the foreclosure action. Next slide, please. So, as we mentioned before, it's very important once you go into default, if that's after 1 missed monthly mortgage payment or 2 or 3, you contact your servicer immediately. You could be eligible for forbearance, and they could possibly take those missed payments and defer them to the back end of the loan, those payments being due once the loan matures. Or you and your servicer can come to alternative agreements in order to address your mortgage delinquency. It is imperative that you do not wait and you seek help. Next slide, please. Okay. After the servicer / financial institution has sent their notices, they'll send a summons and complaint with the court. They'll file a summons and complaint with the court, which initiates the lawsuit. Now the foreclosure action has begun. Next slide, please. Okay. Now, as a borrower, generally you must file your answer to your summons and complaint within 20 days of receipt of the summons and complaint if you were served in person, or 30 days after you received it by mail or in another fashion. However, in the foreclosure context, a borrower is permitted to file an answer 30 days after their first settlement conference. Those are the same conference that Ruhee was referencing earlier. It's very important that you attend that settlement conference. If not, then your answer will be deemed late and you will be in default. Filing an answer is an opportunity to raise potential defenses to the summons and complaint and explain any potential irregularities or errors pertaining to your mortgage servicing. You must file a copy of an answer with the court, and you must send a copy to the opposing side's attorney. Next slide, please. As I mentioned, answers are extremely important. If you do not file an answer, you'll be in default. A vast majority of homeowners lose their property due to failing to file their answer timely. So it's very important that you file your answer timely and attend the settlement conference. Next slide, please.
So thank you, Simon. As Simon was saying, you must file your answer in response to the complaint, and you also must attend these mandatory settlement conferences. So this is the stage where the borrower, with the much needed assistance of housing counselors, prepares the loan modification documents for review with the financial institution. Now, it's important at this stage to have clear, concise, and consistent records. to use in a lack of good faith hearing. It's really important to keep track of all of those financial documents I noted on a little bit earlier. And housing counselors may be called to testify in a lack of good faith hearing to back up the testimony with clear records. So again, keeping track of your bank statements, statements of income, any documents really, it really helps to have those organized. Next slide, please. So what occurs after the settlement conference? First off, the answer needs to be submitted within 30 days following the conference. And it's really important. Courts pay attention to timing specifically, so 30 days on the dot. At this point, it's a really good idea, if you haven't done so, to retain counsel. In New York City, there are free legal service providers in all five boroughs. So it's accessible and it's highly recommended, especially for housing and foreclosure. Next slide, please.
Okay, so thank you, Ruhee. As I mentioned before, one of the things a homeowner / borrower has to look out for are potential scams. Bad actors, fraudsters, and scammers will employ deceptive tactics to convince vulnerable homeowners who are in default that they will be able to resolve their mortgage delinquency if they worked with them. Their objective is not to help you, but to potentially purchase your property for a fraction of the market value or obtain the deed through deceptive tactics. Next slide, please. Fraudsters may promise to pay off your delinquency. They may promise avenues of property retention. They might offer you favorable monthly mortgage rates if you refinance, or they may offer to pay off your mortgage entirely. A good rule of thumb is, if it's too good to be true, it probably is. Fraudsters, once in possession of your property, can take the deed and rent the property to you as if you're a tenant or evict you entirely. So it's very important for you to be aware of these scams and to not disclose important information to unknown third parties. Next slide, please. And here are just some examples of some scam letters that our clients have received over the years. They'll typically say, like, according to our records, you've been in default by this date and you owe this much. And they'll provide you with an option. And they'll put these letters on official letterheads so they make it seem like it's coming from a government agency or your bank or some type of other credible source. Like I said, if it's too good to be true, it probably is. Be very mindful of these type of scam letters. Next slide, please.
Yeah, so following off of what Simon said, the scam letters are, they seem incredibly convincing, but I promise you that's the goal of them. But how can BKA help you with that? For one thing, we could definitely tell you if it was a scam letter or if it was actually a legitimate letter. But we're really here to support you in any way we can. One of those ways is a friend of the court. Brooklyn Legal Services Corporation A participates as a friend of the court. Prior to your settlement conferences, the judge or the referee will ask if there are any members who are representing a friend of the court. This essentially means we have an attorney present at these settlement conferences for those who show up without representation or have questions or just need a little bit of help or advice. We send our attorneys to the courthouse so they can meet with you in the courtroom right then and there as a one way to kind of help you walk you through this process. Another thing is representation. If you feel like you need representation, BKA can help you. We have wonderful attorneys here doing the work and they're excellent at it. And if we find that maybe you're in need in other information, we can provide you with more information about other local agencies that might be able to help you. Next slide, please. All right, any questions?
Thank you so much, Ruhee and Simon. Yeah, I'll get into the Q&A here, but we'll first just leave this slide up with our contact info. You'll see the phone number and the email there are the best ways to reach out to us for intake. If you are looking to get connected with us, even for a quick question, anything from a quick question to full representation, those are the best ways to reach us. But yes, now we'll open it up to questions. So I'll stop the screen share here. Oh, Ruhee, looks like you're in twice. Like I said before, if you can either ask your question in the by typing it into the little Q&A box, you should see at the bottom of your screen. Otherwise, if you'd like to ask your question verbally, you can raise your hand. You'll see the little raise hand button. And when I see that on my end, I'll unmute you. I do have a couple questions here. First one, what if the lender fails to negotiate in good faith?
Sure, I could take this one. So, although the law does not mandate a specific settlement agreement, the law does require the parties to negotiate in good faith to avoid foreclosure where possible. If the court, after holding a hearing, finds that the lender has not negotiated in good faith, the court may issue an order prohibiting the lender from collecting interest and fees for a certain period of time or imposing fines, among other penalties. If the court finds that you, the homeowner, failed to negotiate in good faith, the case may be released from the settlement conference part, permitting the lender to proceed with foreclosure.
Gotcha. Thank you, Simon. All right. Again, go ahead and type your question in or put the raise hand button up. I've got, okay, what happens if a homeowner misses a settlement conference?
That's a great question. So if you miss your settlement conference and the court has not been notified of your absence, you could be released from the settlement conferences and your lender may proceed with the foreclosure. So again, like we said in our presentation earlier, please go to your settlement conferences.
Very good to keep in mind. All right, I have another one here from Anne-Marie. Says, thank you for the presentation. Question, if a borrower is delinquent on their mortgage for 2 to 3 years and the lender or servicer has threatened to foreclosure but has not yet served the summons and complaint and are calling to offer assistance but the offer is still unaffordable, how should the borrower proceed?
I think the first step the borrower should take is to seek out counsel. That sounds like a very peculiar situation. And you would definitely want an attorney to look into that matter further for you. So the first step would be to, reach out to BKA, Brooklyn Legal Services Corp. Or any legal service provider near you so they can look further into your case so they can better assist you.
Also, for specific questions, if you wanted to email us, you can email us at info@bka.org. That's info@bka.org.
And I'll put that in the chat. Thanks, Ruhee. And thank you, Simon. Emery has a follow-up to that. Can the borrower initiate a legal action against the lender?
Once again, that's really case specific. Like I said, I would recommend you reaching out to an attorney, a free legal service provider. Typically, our office doesn't assist clients initiating action against their servicer. We do defend our clients who have received a summons and complaint, and we worked with them to resolve their mortgage delinquency. And in some cases, we'll represent them throughout the whole process. So like I said, once again, Miss Anne-Marie, it seems like you have a very peculiar situation. So we would recommend either reaching out to our organization or whatever free legal service provider is near you.
Thank you both. Yeah, great answers there. And yes, let me put right now into the chat. This is on the front page of our website, bka.org, if you ever forget. But I'm going to put into the chat here the phone number and email. I personally check this info inbox and send it along to Tamara and other team members so we can get back to you very quickly. Anne-Marie says, thank you. Thank you for your question. I have a question for the team. It's more my own curiosity. You mentioned that if it's too good to be true, it likely is the case, and it's a scam. But you also mentioned how these letters really try to look official. What are some other good ways to distinguish between something that's a real letter about a foreclosure and something that's a scam?
Great question, Will. It's tough. It's tough to make the determination. One of the key things you look for is that, a popular servicer, for example, is Celine. So if a borrower has been working with Celine, but they get a letter from some unknown third party, you can assume that it's a scam because you've never been in correspondence with this party prior. You typically look to prior relationships to kind of gauge whether or not this is a valid, or credible letter that the borrower has received. So typically what I tell clients is that if the letter does not come from your servicer or potentially opposing counsel, then you should not at any time disclose your information to that party.
Makes a lot of sense. Thank you. Yeah. So it sounds like it's really. Sorry, go ahead. Yeah.
Kind of to add on to that,
Please.
another great way to check is go to your local government representatives, because they also have the ability to file a complaint for you. Being a fraudster is certainly not in accordance with the law, and it's important to kind of let your local representatives know that this is what's going on, because again, they can look really, really real.
Yeah. Great point. Yeah. So it sounds like too, it's really important to then be familiar with who your lender is and, just generally understand who all the legitimate players are in your foreclosure, your loan. Yeah. Excellent. Thank you both. Amory has a follow-up here. The lender states that the file has been submitted to an attorney for legal action, but it has been more than 1 year. And then another follow-up, does the foreclosure process take 2 years?
There's no good question, Emery. There's no definitive timeline for foreclosure. It could take, there's I don't even want to speculate because it really differentiates between case by case. So there's no like X amount of time before an action has to be taken. So like once again, it seems that you have a situation that you're dealing with. So like I said, I recommend you reaching out to our office. Or, like I said, any free legal service provider that's convenient for you or nearby you.
Absolutely. And Anne-Marie, we can reach out after this with the email you registered for this webinar with, and we can, if you want to follow up, so we can just shoot you an email right after. All right. Okay, perfect. Thanks, Anne-Marie. Any other questions? Again, you can feel free to type into the chat, or you can use the little raise hand button and ask a question verbally. Simon, I just have the Teams open for you, so I'm gonna send it to you, and Ruhee, I'll share it with you as well. Anne-Marie just sent over her email, so I'll send that to you.
Sounds good.
And thank you, Anne-Marie. We will schedule an individual appointment for you, and you can speak with the legal team.
Perfect. All right. Any other questions from anybody else? Ruhee or Simon, any other final tips, good things to keep in mind for the folks watching?
The first thing I would say, like Ruhee had mentioned, seek help, do not wait. The longer you prolong this, the worse it will be, but there is assistance out there ready and willing to help you. So that would be my suggestion.
Yeah, I think just very similar to Simon, don't wait. The moment that something comes up, it's important to just get talk to the right people, your free legal counsel and your legal services. And just things can pile up very quickly. So if this is on your radar, just pay attention to it. But yeah.
Excellent. Well, I don't see any other questions. So I think we'll go ahead and wrap it up there. Thank you so much to Ruhee, Simon, and Tamara for joining us. The presentation was wonderful. We will be posting the recording of this onto our YouTube page, so if you want to refer back to it, we can also, it might not be tomorrow, but we generally like to send the slides out to folks who attend if you want to refer back. And again, if you have any other questions or want to follow up on anything, please do reach out to us. The phone number and email are in the chat. They're also right on the front page of our website, bka.org. It's 718-487-2300, and you can email info@bka.org. So with that, I think we'll say goodnight, and thank you again to Ruhee and Simon.
Thank you, Will. Thank you, everyone, for attending.
Yeah, thank you so much, everybody.
Bye-bye.
Good night.